Good evening. This meeting will come to order. This is the Milford Zoning Board of Appeals, July 2023 meeting. Let's begin with the Pledge of Allegiance. Thank you. Roll call, please.
Mr. Dubois.
Here.
Mr. Ferrante.
Here.
Ms. Hirsch.
Here.
Mr. Montano.
Here.
Mr. Smith.
Here.
Mr. Soto is excused. Mr. Wolf.
Here.
And Chairman Tuzzola.
Here. Also present this evening is Meg Green, our recording secretary, and Stephen Harris, our zoning officer. For your attention, item number 4, 1534 New Haven Avenue, has been withdrawn if you're here for that. Let's see. Also, Mr. Soto is not here this evening, so Ms. Hirsch, would you please fill in for him?
Yes, Mr. Chairman.
Thank you. With that, we can get started.
Item number 1, 12 Francis Street, MBP 6/84/2, R7.5, Kevin Kersaden Esquire for Antoinette Vall and Joseph Vall, appellants, appeal the decision of the zoning enforcement officer in accordance with the provisions of section 9.2.1 regarding April 20, 2023, notice of violation and related decision that there is a violation of sections 5.7.2, 5.7.6.6, 5.8.6.6, 5.8.6.7 of the MZR.
Good evening, Mr. Chairman, members of the Commission. For the record, my name is Kevin Kersaden. My office is at 3 Lafayette Street here in Milford. We've been having discussions with staff on this, and we asked, due to time reasons, that you open the public hearing and table it, what will allow us to continue our discussions until the next meeting, if that's possible. Thank you.
It is possible. Okay, thank you. All right, Stephen, we don't have to vote on this. We just continue it? Okay. All right. Item number 1 is continued till next month.
Item number 2, 25 8th Avenue, MBP 9/102/9, R7.5, Robert Maslin Esquire for S. Swan, Laurel Beach Association, and E.T. Kolakowski III, appellants. Appeal the decision of the zoning enforcement officer in accordance with the provisions of section 9.2.1 regarding certificate of zoning compliance for use of land or building, certifying each of the existing developer lots, lot numbers 23, 24, 25, and 26, as shown on maps R33 and F580 are legally non-conforming lots of record.
Okay, so Mr. Maslin, I want to ask you a question.
Sure.
The packet that you handed us this evening, is this part of your presentation or additional information?
My presentation will run through that in basically a summary fashion. So it's, I guess, a little bit of both.
Yeah, I mean, it's quite a bit of information, so we're just wondering what it's about. So whatever commissioners, most of you have this in front of you? Well, I guess you'll have to skim through it as he's doing his presentation. Okay. All right, sir, go ahead, continue.
All right. Good evening, Mr. Chairman and board members. I'm attorney Robert Maslin. My office is at 30 Old Kings Highway South, Darien, Connecticut, and I represent the appellants or the applicants or whatever terminology you'd like to use. Attending the session of the hearing this evening are John Shanley, president of the Laurel Beach Association, Mr. Kolakowski, who is one of the appellants, and I do not believe that Suzanne Swan will be here. As mentioned in the notice, this is an appeal of the...
I'm sorry to interrupt you again.
Yes,
Please
sir.
pull that microphone closer.
Oh,
Thank you,
I
sir.
had that problem last time.
Thank you. I really
Is this-
appreciate you doing
is
that.
this
Thank you.
better? Okay. Okay, all right. All right, this is an appeal of the zoning officer's issuance of a certification relative to these lots that are at issue at 25 8th Avenue. Most of the reasons why the decision should be reversed are laid out in the letter, the attachment says we discussed a moment ago. I'll walk through the letter and talk about the background and try to go point by point. It may not follow the sequence of the letter directly, but I'll try to make it simple and understandable. The property's in the R125 zone or 12.5 zone, which has a minimum lot area of 12,500 feet. The lot depth is 100 feet. The minimum width is 80 feet, and the minimum depth is 100 feet. And this particular parcel at 25 8th Avenue is, according to the assessor, 0.49 acres, which is actually less than the 25,000 square feet that you would need to create two conforming building lots. There was a brief discussion at the end of toward the end of the hearing last time about jurisdiction, and I just wanted to clarify that it's our position that there is jurisdiction. Mr. Harris mentioned that anyone can file an appeal of a zoning officer's decision, which we've done. His comment was a little broader than that, and I don't think he meant to be any broader than to say there's no jurisdiction for a Board of Appeals to interpret or enforce a restrictive covenant. I just wanted to make that point clear. My three clients are aggrieved. The Laurel Hill Association has been involved in ZBA matters previously. They've been in court as a taxing district for the area where this property is located. They do have standing. In addition, they have been given non-exclusive authority to enforce the deed restriction. Well, it's not the deed restriction portion of the declaration of merger. Mr. Krolikowski has standing because he created the document and he retains the ability to enforce the document. He also obviously has a specific interest in what happens here. And finally, Ms. Swan owns the property across the street, well within 100 feet of the subject property, and has statutory aggrievement. The reasons for reversing the decision are primarily the declaration recorded on the land records. Now, first, we cite this before you as evidence of an intent to merge the property under common law merger doctrine. The document itself is not just a restrictive covenant, as the owner's attorney and Mr. Harris have characterized it. It is also plain evidence. If you read the document, you'll see clearly that there's an intent to merge, and that's common law merger. That is something you do have jurisdiction over because you do deal with questions of merger in the realm of zoning regulation. I'm not going to read chapter and verse, but basically the document states clearly that it is our intent, meaning Mr. Krolikowski and his former co-owner, to declare for all purposes, for all future time, that the premises known as 25 8th Avenue, Milford, shall be considered one parcel of land for all purposes. And that the lots shown on a I believe it's 1930 map, are considered merged into one parcel, again, for all time and for all purposes. So one paragraph, for all time and for all purposes, is mentioned 3 times. Again, that's evidence of common law merger. Now, the declaration was actually delivered to the Doyle's attorney when they purchased the property in one package. The attorney received the declaration, the warranty deed, and the attorney also witnessed and acknowledged the signatures on the purchase money mortgage, and all three documents are recorded in the land records back to back in the same book. The declaration and the deed both say return to, and there's the attorney's name and address in Brantford, who was the attorney who represented the Doyles. So there's no questions the Doyles accepted this, knew about it through their attorney, and eventually the document was recorded. So with respect to the argument that there's no consideration or it's not enforceable, or that the Doyles knew nothing about it, is just not true. Okay, and also in our original papers, we included a 1973 set of papers from the prior owner, Dr. Gerlach, Philip Gerlach, who was applying for a zoning permit for addition on the house. And in that file is a drawing that measures a setback across all of these lots with a total setback number of 127 feet. That's additional evidence of common law merger, if nothing else. We've heard that there's no map recorded. No map is required to be recorded in order to have a common law merger or any kind of other kind of merger. I would also mention that under the regulations, the zoning regulations, under two general versions, you had one where the mere ownership of adjacent property was sufficient to merge the lots. And then more recently, there was a version of 6.4.2 that had specific items that are to be considered on the question of merger. There's a pretty well settled principle that says once lots have merged, you can't unmerge them. So we have two different ways that these lots have merged. One, the declaration. Second, the zoning file itself, coupled with the various versions over time of 6.4.2. Another point that Mr. Crusaden made was that Lot 23 and maybe Lot 24 is somehow protected under Section 826A, and that's a section that says once a subdivision lot is approved by a planning commission, the lot is not subject to subsequent changes in the zoning or subdivision regulations. Problem is, lot number 23 was divided back in 1976, and in the package you have that I submitted, there's a copy of the deed that affected that. And what happened was the owner of number 25, 8th Avenue, conveyed a 20-foot strip from street to street to the adjacent landowner, thereby splitting that into two pieces that attached to the adjoining lots. It was 22 and 24. So lot 23 no longer exists, period, except I think that the assessor has just assigned that as assessor's lot 23, but it doesn't exist as was shown on any of the previous maps. And lot 24, having been enlarged, is no longer in the configuration that was shown on those maps either. Now I'll move to, and I'll get back to 8-26A in a couple of minutes. The status of section 6.4.2. When I first appeared last month, my impression was, based on the regulations that were online available for download, 6.4.2 still existed. You have to do some digging to figure out that that section was repealed. And it was brought to my attention just before the meeting that that in fact had occurred. Excuse me. So with that section being repealed, this is the impact. The Planning and Zoning Commission removed the ability of the zoning enforcement officer to issue a zoning permit for substandard lots that met the characterization that the owner currently or prior owners did own adjacent lots. In essence, 6.4.2 provided protection for substandard lots if the owner met all of the conditions listed in the regulation. And when the commission repealed the regulation, it took away the ability to get a zoning permit based solely on a review and a decision by the zoning enforcement officer. And what the owner's left with is substandard lots, and if the owners would like to develop those, they have to follow a process and apply for a variance because they're dealing with a lot that is not large enough for a single-family house under the regulations. So unlike what I think you're going to hear, the argument that repealing 6.4.2 eliminated any possibility of merger, that's just not the case. The language in 6.4.1 and 6.4.2 starts off by saying you can get a zoning permit if. You can get a zoning permit if you meet the following conditions. It's still there, subject to the moratorium for 6.4.1, where you have substandard lots where the owner, current and previous owners never owned adjacent lots, but it's not there for 6.4.2. The moratorium, that's an interesting history, and I'll grant that there's a lapse in it, but I did find minutes where the Planning and Zoning Commission attempted by motion, without going through the regulatory approval process, they tried by motion to just extend it, and I think what happened was they realized they had to have public hearing and notice and all that, and there was a lapse. But the lapse, the moratorium, according to its terms, applies to certifications under section 6.4. It's not limited to 6.4.1. It has nothing to do with 6.4.2 because at the time the moratorium was put into effect the first time, 6.4.1 didn't exist. It had been repealed. In addition to that, there's really no formal statutory or regulatory process for the zoning enforcement officer to issue a certification as to the status of lots. Zoning enforcement officers under the statutes issue zoning permits and they issue certificates of approval on the back end of a project where the owner or the developer is asking for a certificate of occupancy, and a statutory prerequisite to the building permit itself and to the CO is a sign-off by the CEO that the plans on the permit side and the finished project on the CO side all comply with the relevant zoning regulations. There's really nothing in the statutes and nothing in the regulations that allows the CEO by himself to make any certification as to the lots. If he's reviewing a zoning permit application for a building permit, that's a different story. So what we end up with is a decision here which I'm not sure is appropriate in terms of being, or shouldn't be treated as a final binding decision on anybody, because, and I think as Mr. Krasation said, they still have to go through a process of lot line revisions and maybe consolidation of lots. So they're not done. So it's really not a final decision, but nevertheless, the owners thought it appropriate to publish notice of the certification decision in the legal notices in the paper, which starts a 15-day appeal period. And frankly, that's why we're here, because we had that 15-day window to bring this before you. So, legal points. Merger can be determined simply by the owner's intent, which is what we have here. We have very strong evidence, and this is not the same type of situation that I think somebody asked about last time. I believe it was another application. I don't have the minutes here, but somebody asked about another application, also, God bless you, down in Laurel Beach area somewhere, and asked whether it's the same situation. It's not, because this application or this particular parcel and the appeal involve the declaration of merger, which I don't believe the other one had anything like that. In addition, we had the other sketch with the setback measured across all of the original boundaries in the old zoning file. Merger does not require a recorded map showing the maps as a single parcel, showing the lots as a single parcel. It's just not, there's no statutory requirement, nothing in the regulations. And the declaration of merger basically serves the same purpose, because if you hire a surveyor to go out there, the surveyor is going to pick up the declaration and show that on the map. And if the surveyor does it the right way, he's going to show this as a single lot with probably a notation, see the declaration of merger with a reference to the volume and page of the land records. That's just how surveying is done. We don't have a survey here, but the declaration serves essentially the same purpose. And once the lots have merged, the zoning enforcement officer can't decide that they're unmerged. That's just not within his authority. If there were a, for example, if you had a lot that was large enough to make two complying lots, then the ZEO might be able to sign off on what's called a free cut or a first cut, where you're not making the third lot since the creation of the first set of subdivision regulations, but we're not dealing with that here. That's why I mentioned the lot area, and basically you need 25,000 square feet, and they don't have it. That leaves us with apply for a variance on the lot dimension requirements and or a subdivision or re-subdivision application, or see if they qualify for a first cut. But this certification process just doesn't apply, and the ZBA should reverse just on that basis. Now, one final point, and I'm actually not done with the research on this, but it's ultimately going to be for a court to decide. Apparently, there's an assumption that because historically there was a set of regulations adopted in 1929 for the Commission on Town Plan, and it's a set of regulations that applied to the layout of roads and the platting of subdivisions. The problem with, and that assumption then leads to a conclusion that lots that were shown on the 1941 map are somehow protected from subsequent zoning and subdivision regulation changes. I don't think that's the case. And the reason I say that is the Town Plan Commission across the state, as they existed in the 19-teens and 1920s and 1930s, were responsible for reviewing street layouts, and they were responsible for approving improvements to municipally owned property. They did not have jurisdiction to approve subdivisions as we know them today. And those 1929 regulations don't even define subdivisions as the creation of 3 or more building lots, which the current regulations do say. So I've included in my packet two cases that illustrate this. Unfortunately, you can search Westlaw and other online sources till you're blue in the face, and you're not going to get statutes from 1910 or 1918. I've tried to go through that process with the state library, and it's very slow. But Jacobs versus ZBA, which is a Westport case, talks about town plan commissions and actually says that a town plan commission relative to a lot shown on a 1922 map were not protected subdivision lots and didn't get the protection under Section 8-26A. Then we have Beach versus Milford Planning and Zoning Commission, which is a 1954 case. And in that case, the court, and this is the Connecticut Supreme Court now, the court reversed the commission's denial of a subdivision application because the denial was based on an improper reason. But the court also talked about the Milford subdivision regulations and basically said the first real subdivision regulations that went into effect in Milford were 1954. And that was following a statutory process that enabled the city of Milford to actually create a planning commission or a planning and zoning commission with authority, full authority to issue approvals of subdivision lots. And finally, I would just mention that the 1941 map that is already in the record has a handwritten note on it, approved by Town Plan Commission. It doesn't say approved by Planning and Zoning Commission. It doesn't even say it's approved as a subdivision. That Town Plan Commission goes back to the 1920s or 19-teens, and its authority under its enabling legislation was simply to approve the layout of roads. So therefore, there's no protection under 836A for any of the lots that now consist, any of the lots that 25 8th Avenue now consists of. So that's all the points in my letter, that the cases are mentioned. I would just make one final note that Mr. Kersaden attached several cases on the issue of interpretation or enforcement of restrictive covenants, private restrictive covenants, and none of those cases involved a situation where there was actually a declaration of merger. So none of the cases really apply here. And that concludes my summary run-through of the points in my letter.
Thank you, sir. Commissioners, any questions for Mr. Attorney Mason? No questions? Okay.
Thank you very much, Mr. Chairman.
All right, who would be next speaking on this appeal, if any? Is there anyone else speaking on this appeal?
Not on my behalf. There are a couple
Okay.
of gentlemen are here if you have any questions for them personally.
Okay,
but
thank you. Mr. Harris, do you have any remarks? You had given us some last.
I'll let Mr. Kersaden go.
Mr. Kersaden.
Good evening. For the record, Kevin Kersaden, my office is at 3 Lafayette Street. I represent the owner of the property, and we are the applicant for the lot certification process. So to start off with, we've followed the city rules and regulations with respect to these lot certifications, not only for this particular property, but for other properties in Milford, including another property in Laurel Beach that you heard an appeal on several months ago. This situation is exactly the same situation as that previous appeal. I'll explain why in a minute. The city attorney disagrees with Attorney Maeslin's point that there's no procedure to certify lots. I've had numerous conversations over the years with the city attorney's office, with Stephen Harris, with David Sulkus, with Joe Griffith, all about, especially since the merger 6.4.2 merger provision was deleted. And this is the process that the city's been following. They have processed, I don't know, I've probably done 26 or 30 of these lots in the past couple years, and many more prior under the old 6.4.2. And there's been many other developers and builders and attorneys in town who have done the same exact thing. So this is the process. The regulations are interpreted by city staff and the Planning and Zoning Board, and it's those regulations that we followed, and the city attorney supports that decision because I had the very discussion with Attorney Burcham several months ago about certifications of lots and how the city was handling it, and he said, no, the city does have the authority to certify lots, and he disagreed. Certify them as zoning compliant, certify them as potential development lots, whatever you want to call it. So we've followed all those rules. At the last hearing, Mr. Harris read into the record the city's position on it, including an important point, once again, from the city attorney's office that's opined that the Zoning Board of Appeals does not have the authority to adjudicate private deed restrictions, which goes back to my point about why this is exactly like the other appeal. What the applicants are asking you to do is to act as a court of law and to determine whether a declaration of merger, which is really an attempt at a private deed restriction, whether that's valid or not. And so the cases I've submitted talk about private deed restrictions and restrictive covenants and things of that nature because there are no cases that talk about declaration of merger, because merger is a decision that is made by a local zoning authority or the Zoning Board of Appeals based on their zoning regulations, because that's the authority that's vested in you through the state statute 8-6. You don't have, respectfully, you don't have the authority to make determinations about whether declarations or private deed restrictions are valid or not. That authority rests with the judge of the Superior Court. They have another avenue. They can bring an injunction to the court, to a judge of the Superior Court, asking them to enforce what they claim is a declaration of merger. What should have been done is that they should have, if they wanted the lots all to be one lot, they should have filed a lot consolidation map, had it signed off on by the city planner or the chairman of the Planning and Zoning Commission, and recorded that on the land records. That's how Milford processes these things. So I know you've had, I had a 2.5-page memorandum with a bunch of cases and some exhibits that I had submitted last time. I can just highlight the basic points of that really quickly, and just based on, I have a couple of other notes based on Attorney Maeslin's recent filing. So I just want to see if I had any other points from his recent comments here. So all of those comments about the restrictive covenants and the declarations and my cases and what my client knew at the closing are not really in front of this tribunal. Also, I've learned a painful lesson in dealing with the city with respect to the right to subdivide, is that there is a public act from 1929's Chapter 169 where there's a special act that actually increasing the powers of the Town Plan Commission of Milford in 1929, which gave the town at that time the right to subdivide parcels. So I've learned that from being on the other side of this issue as well. So one of the lots, lot 24, is actually protected by 8-26A, in addition to being a lot of record as certified by Mr. Harris. Let's see if there's any other points from my memo. You know, I think just to keep it simple, I'll leave it at that unless anybody has any questions for me. Thank you.
Questions for attorney? No? No. Okay, Mr. Harris, are you speaking on anything?
Just to quickly summarize what I said last month and just stress the main point is that the board does not have the authority to adjudicate a private deed restriction.
Okay, thank you. Attorney Maslin, we'll let you have the final rebuttal.
Thank you, Mr. Chairman. I'm not going to belabor too many points here. I would note that just as any other regulation and procedure, sometimes they can be in place for a long time, but until a court actually decides whether they're valid or not, it doesn't mean that they're valid just because you do it over and over again. And again, my point, and because the town attorney, whether it's Mr. Woods or Mr. Burcham, opines, still doesn't make it a final decision one way or the other. You are a quasi-judicial body when it comes to reviewing decisions of a zoning enforcement officer on an appeal. So I wanted to make that point too. And I'll just get back to this declaration. One more point. This is no different from reading a map, which you do on variance applications. It is clearly an intent to merge these properties or merge these lots into a single parcel. And it's much more than simply a restrictive covenant between private parties. Thank you again for your attention and consideration.
Thank you. Any further questions, commissioners? None? Okay, this hearing is closed. I had asked for public comment, and no one was coming forward. Okay. So you will either uphold or overturn the zoning officer's decision.
We've got both Mr. Maslin and Mr. Crusaden stating that this is headed into Superior Court. I heard that both. And we don't want to pass the buck here, but we've never changed a decision from Mr. Harris, and we know where this one is going. It's the only comment I would have. We have, regardless of a survey being filed, this merger of intent exists. I acknowledge it's going into Superior Court, like Kevin also stated.
So what would your motion be?
Uphold.
Okay. We need a second. Seconded. We have a motion to uphold the zoning officer's decision. Mr. Montana?
With the motion.
Ms. Ferranti?
With the motion.
Mr. Wolf?
With the motion.
Ms. Hirsch?
With the motion.
I'm with the motion. Decision upheld.
Item number 3, 128 Beach Avenue, MBP 60/743/11, R7.5. Thomas Lynch Esquire for Mervyn Klein, owner. Vary section 4.1.1.1, proposed pool front yard setback from Blackall Road to 15 feet where 20 feet required.
Good evening, Mr. Chairman, members of the board. Just for the record, my name is Thomas Lynch. I'm an attorney with the law firm of Lynch, Trimbicki, and Boynton. My office is located at 63 Cherry Street. And I'm hopeful you can pull the plans up. All right. Meg, do the board members have paper copies of the revised map?
They do, and
Okay.
several have brought their laptops, so I would suggest if Stephen might turn the monitor maybe flat to the wall so that everyone can see it. Or somebody strong can do that.
Well, I'm going to be brief, and if everybody has a paper copy of it, I'm good.
Okay.
So,
We do.
okay. So we left off continuing the public hearing last month. The application that we presented to you at the June meeting consisted of variance requests There were two of them. There was a request for the front yard setback, because remember, there's two front yards on this property, both on Blackwall Street and Beach Avenue. So there was a request for the projection variance for the pool equipment. That was one application. The second request was for the pool itself. So after we heard the comments of the board members, we went back to the drawing board. We've revised the plan. So if you look at the plan, you can see that the pool equipment has now been removed from the front yard setback off of Blackwall. It's actually on the other side of the pool, on the Beach Avenue side of the pool. So previously, if you look at the revised map, in the upper central area next to where it says proposed paved driveway, the pool equipment was there. So we've eliminated that variance request by moving the equipment to the other side of the pool. And what we've also done, and again, if you remember Mr. Cooper, the architect that was here with me, the client was desirous of having a standard 42-foot long pool, a lap pool. So we maintained the size of the pool, but what we did was we moved it now further back out of the setback. Before, there was a 15-foot projection. Now it's been reduced by 5 feet. So really, it's gone from 5 feet, gone to 5 feet now. It was 7 feet before. In other words, it encroached within the setback 7 feet. Now it's only encroaching into the projection setback 5 feet. So we've made two compromises to the plan, removed the pool equipment, eliminated that variance request, and also moved the pool itself. The client, again, really didn't want to move the pool any further towards Beach Avenue, because then it would almost be projecting or coming into the front yard of the house rather than the side of the rear. So I think where it's located is certainly reasonable. And again, I remind you, we did have an email that was sent in support of this application from the adjoining property owner at last month's meeting. So with those two changes, the elimination of one of the variance requests and the modification of the location of the pool, we'd ask that you approve these plans.
Okay, one of my questions is because we can't put it up there and it's very small here to see. On the front part of this pool, there's a proposed patio. What
Yes.
is the dimensions of that patio?
It looks to be 14 by 30, Joe. It's 30 feet wide, and again, it's either 16 or 14 feet by 30.
Okay, so, I mean, that's a large, not to beat this, I know you're here and you made some changes, but wasn't it possible for that patio to be made smaller? So it was pulled forward a little bit more, and you didn't have 13 feet on the rear side.
Well,
I know you've shortened up the pool on the back side,
Right.
but probably by what was it only about 3 feet?
I think by 2 feet, correct. But again, the comment that I had back from the architect, and he was meeting with the client, they really didn't want to pull it too far forward, because then it almost looks as though it's coming into the side or the front yard rather than being a pool in the rear of the portion of the property. And it's a good-sized piece of property. The residence, again, reminding you that the new residence itself is going to be constructed fully zoning compliant. So the only request on this plan is for that small encroachment for the pool into the setback. And again, I stressed the argument at the last meeting that Blackwall really isn't the primary the front yard. It's sort of a secondary front yard. There's no traffic back there, or literally virtually no traffic back there. And typically in situations where we have two front yard setbacks that we have to hold, the board has been cognizant of that and willing to work with people on the variance requests.
Okay, Sarah, do you have a question?
No question.
No. Any other Questions? Okay, anyone else speaking in favor? Is there anyone here opposed? No further questions by the board? Okay, the hearing is closed.
Thank you.
We need a motion? Remembering, we make our motion in the affirmative, and then we'll have our discussion.
All right, motion to approve.
Second? We have a motion to approve, and we have a second. Discussion? Second. We have a second. Thank you. Discussion?
I have something.
Right.
This lot well exceeds the minimums for this zone, including lot area, lot width, and lot depth. A rear yard setback on Blackall Road would be 25 feet. As a front yard setback, it's 20 feet. That's already allowing them more room to build. I see no hardship in any way.
Thank you. Any other comments? No other comments?
Was this, did we have this up yet last week? We did. And in support and favor, can we ask that prior, or is it over?
We left this open. You weren't here last month on this, so
Okay.
actually I can probably not have you vote on this. And Mr. I think Michael Smith, you were here?
Yes, it was.
Okay.
Thank you.
I'm going to switch our board members. Mr. Wolf had a question, but he wasn't here, so he's not familiar exactly what took place last month. So, Mr. Smith, please vote in this when we get to the vote. Okay. Any comments from you, Mr. Smith?
Yeah, as I mentioned last month, I think I appreciate that one of the neighbors was in favor of it, and I think Attorney Lynch said that the other neighbors have been noticed and there wasn't objections to it. Given that it is a double, that you have streets on both sides, or double front yard, I do think there's a hardship there, and I don't see a problem. And I appreciate the modifications that have been made.
Okay, any other comments? All right, we had a motion to approve and we had a second on the motion. Mr. Smith?
With the motion.
Ms. Hirsch?
With the motion.
Mr. Montana, I'm sorry.
With the motion.
Ms. Ferranti?
Against the motion.
I'm against the motion. I think there's still room for improvement.
Right. Thank you.
Item number 5, 40 Morehouse Avenue, MBP 30/639/12, R5, Thomas Lockwood, Cheryl Quinlan owners. Vary section 4.1.4.3 to allow front deck where such deck is not permitted because it's not the minimum allowed.
Good evening. For the record, Kevin Kersaden. My office is at 3 Lafayette Street. With me tonight are the owners, Cheryl Quinlan and Thomas Lockwood, sitting behind me. This is a lot that I was familiar with. I actually represented the seller of this property to the buyers a while back, and the parties found out after the fact, and I found out after the fact when Ms. Quinlan contacted me, that this house needed to be elevated, and that there was a letter in existence somewhere in the city but not recorded on the land records, and also not part of the zoning file. I think it was either post Irene or Sandy, where there was a letter sent by Mr. Griffith instructing the previous property owner that the house needed to be elevated. Whether that property owner ever received that, I don't know. I wasn't aware of that until well after the fact. So that's one of the hardships, is the fact it's in a flood zone. The second hardship is that there's a 25-foot wide city drainage easement in the back of the property, so it's not like somebody can push the house back further away from the street. There's also about 300 or 400 feet of inland wetlands on the rear of the property and then immediately adjacent to the property. The lot does pre-exist the zoning regulations. It's undersized as far as width by about, I think the front yard, I spelled it out in that brief memo I had submitted, but I think the lot's 35 feet wide where 50 feet are required. And it's also undersized, I think, by 1,000 feet. It's an R5 zone, but once again, it was created and the house was built before the zoning regulations. So it's a single-story beach, kind of one of the classic beach bungalows in the Bayview area, also in this Point Beach area. It needs to be elevated. In order to access your house once it's elevated under the Milford zoning regulations, you're allowed a certain amount of the minimum amount of either stairs or decking to access those doors. In this particular case, Mr. Harris had determined that what was being asked for was not the minimal amount required, because it's a front deck that would stretch across the, whatever it is, the 18-foot wide house all the way across, instead of just starting on one side and then stopping in the middle at the door. Under the zoning regulations, without a variance, they could have done a 2-foot wide, or they probably could have came in 2-foot wide deck. This deck is 4 feet wide by 18 feet long. It's really a front porch if it were to be approved. Under the zoning regulations, they'd be allowed to do a 2-foot wide, and I don't know that that would meet building code or not. I think that the 4-foot wide meets building code, but it leaves very limited room for opening the door or maneuvering in the front of the house. It's one of the, I think there's only 2 means of ingress and egress out of the property. So there are many different hardships with the property, including the fact that it's in a flood zone and now needs to be elevated. I don't know if my client has anything they want to add to that or not.
Hi, my name is Cheryl Quinlan, and I'm co-owner of this house. Without repeating everything Attorney Crusaden said, finding the house had to be lifted. We've cooperated fully with the City of Milford, because if you don't lift the house, it could impact the city's ability to be part of the federal flood program and to get the discounted rates. So ever since we discovered this, we've done everything to bring the property into compliance. 2 other points. I think we've had about 6 neighbors send emails in to the city saying they had no objection to this. And lastly, from a safety standpoint, my granddaughter, the intention is to have my granddaughter live in this house, and she's got a learning disability. So I'm concerned about her ability to get out of the house. So I think that's it. Thank you.
Pending your questions, I don't have anything further.
With this 4-foot instead of 2, it's got to be right all the way right to the street line, correct?
I think it is still about 2 feet back, it looks like, from the copy of the survey that I have. I think it's still 2 feet back from the street line. But the 4 feet, I think, is the minimum required to access it. The question is the width, is the length of it, I think, is Stephen's point.
Right. There's going to be a side staircase coming up, and where's the door? Is it right in the middle of the structure?
Correct.
Okay. Questions for Attorney Crusaden? Questions? No? All right, anyone else speaking in favor? Is there anyone here opposed?
Mr. Chairman, I'd just like to clarify something for the board.
I'm sorry, I didn't hear you.
I'd just like to clarify something for the board. No one's saying that the applicant's, the depth of the landing has to be 2 feet. On their plan, it's shown 4 feet deep by 22 feet wide. Spans the width of the house. So just to clarify what the regulation says, it allows the minimal stairway and landing if you elevate your house in place, even if that stairway and landing is inside the setback. So the stairway and landing is inside the setback. So staff determined that the spanning the width, the entire width of the house was not minimal, which is why the applicant is asking for the variance.
What would be minimal? How wide?
Well, I'll say that the front door is in the middle of the house.
Right, so rather than this porch going all the way across the house, how far beyond the door, what's a minimal width? What kind of elbow room do you have up there?
If the proposal was to start the front deck at the front door and then go over to the side, I would have, she wouldn't be here.
So half the house rather than the whole width,
Yes.
which would leave room for maneuvering in and out.
Mr. Poseidon, do you have any remarks?
Well, I think that there's two different ways this could have been approached. This is one way, and the other way is a variance of just the front yard setback for the entire width of the deck. It's a very small house. We don't think that the request of having the deck extend across the front of the house is a large ask. And I also, as far as the maneuverability on it, 4 feet wide should be wide enough, I guess, but it's just that with other things that go along with front door access, groceries and things, and you have more than one person trying to get in the house at the same time, I don't think that this is, I think it's a subjective viewpoint that the halfway across the house is minimal and acceptable, but to extend it the full width of the house so that it also looks balanced for a house this old, I don't think it's a really that big of a ask for the commission.
Okay, thank you.
Thank you.
Any other questions, commissioners? None? Okay, this hearing is closed. We need a motion.
Motion to approve?
Seconded. We have a motion to approve. We have a second on the motion. Discussion? I don't have a problem with it being all the way across as far as balance. There's really no reason to stop it there. Any other comments? Okay. All right. We have a motion. We have a second on the motion. Mr. Montana? With the motion. Ms. Ferranti?
With the motion.
Ms. Hirsch?
With the motion.
Mr. Wolf?
With the motion.
I'm with the motion. It's approved.
Item number 6, 10 4th Avenue, MBP 9/73/3, R10. Stephen and Pamela Moore, owners, vary section 3.1.4.1, side yard setback to 6.7 feet, where 10 feet required for garage expansion.
Good evening, I'm Steve Moore. Am I close enough? Okay, I know it was tricky for folks. I live at 10 4th Avenue Extension with my wife Pam. I'm the applicant here. We are seeking to vary the side setback at the southeast property line of our house alongside our garage from the 10 feet required to 6.7 feet. The purpose is to widen the garage. I've included an explanation in the application, which I think is available to everybody. It's part of a larger renovation. I would point out that every other part of the renovation is compliant. This is the only requested variance. It's a couple of feet. As I explained in the written explanation, it's an odd property line because although it's straight, it's not perpendicular to the street. So this line, which is between our property and the property of Laura and Dave Speranzini, who are our immediate neighbors on that side, it moves toward our house as we come to the street. So our property consequently gets narrower toward the front, and Laura and Dave's gets wider toward the front in that area. And that's why we're struggling with the garage up toward the front. Back part of the garage is fine, but the front is going to intrude if we get it to a point where we can really get 2 cars in there and open the doors. So that's the reason for our request. The other thing I'd point out, which I think is important, is we do have 4 letters of support or messages of support posted. Most importantly, the Speranzinis, they don't object. There's an email from Dave to me that Ms. Green was kind enough to post confirming that. We've talked with them. We also have letters from the Shanleys, the Corcorans, Mr. Corcoran is here, and the Wolves, well, Mrs. Wolf, expressing no objection to this. Those 3 are the next most proximate neighbors on this part of the house. We've talked to not everybody else on the abutters list, but most people, and I just don't think anybody's fussed about this. So that's all I've got. If you have questions, I'm happy to answer them or try to or provide other information. And otherwise, I would just thank the board. I know you're volunteers. I appreciate your time.
Thank you, sir. Questions for Mr. Moore? None? Okay. Go ahead.
It appears on this plan that the back of the expansion is right at the 10 feet. It is compliant. Is that true? And then it goes into the setback as it moves towards the street?
Yeah, but the back is compliant. In fact, if we can't get the variance, we'll expand the garage, but we'll expand the back of it to the 10 feet, and the front of it will have to be narrower, so there'll be a jog in the wall. It'll be kind of weird, and I don't think that's what Dave and Laura want to look at, but that's what we would have to do.
Okay.
Mr. Moore, is it true that parking is very difficult in your neighborhood?
Parking gets crowded in Laurel Beach at times. Weekends are tricky. There's a field across from us that's available for parking, and I have a car in there. Well, it's here, but when I go home, it'll be in there. So, but that's available. It does get crowded at holidays and nice weekend days.
But with this addition, you'll be able to put 2 cars?
Yeah, and 2 cars is all we've got.
Thank you.
Thanks.
Anyone else speaking in favor?
I don't have anyone.
Is there anyone else speaking? Is there someone behind you who said they're in favor?
No, Mr. Corcoran's here, but he's submitted a letter.
If they want to say they're in favor, they can just come up and state their name and say they're in favor.
Sure.
It'd be on the record.
Good evening. Thank you. My name is Patrick Corcoran. I live at 235 3rd Avenue in Milford. I'm an adjacent neighbor to the Moores. You, in fact, have a letter that I've signed in favor of the plans. So now verbally, you also have that on record. Any questions of me?
Thank you for your comments, sir.
Thank you.
Okay, is there anyone else in favor? Is there anyone here opposed? Anyone opposed? Any further questions? This hearing is closed.
Okay, thank you.
We'll have your answer in 2 minutes. Okay, we need a motion.
Motion to approve?
Second.
We have a motion to approve. We have a second. Discussion. Discussion, any? It's a small variance, as he had stated. He's going to probably do something with the rear, but it's a matter of balance. I've been by the property. I don't see any problems with going out on it. Any other comments? Okay, we're ready for a vote. Mr. Montana?
With the motion?
Ms. Ferranti?
With the motion.
Ms. Hirsch?
With the motion.
Mr. Wolf?
With the motion?
I'm with the motion. It's approved.
Item number 7, 87 Bayshore Drive, MBP 28/566/3, R7.5. Amy Berkowitz, owner. Vary section 4.1.4, front yard projection to 11.5 feet, where 16 feet permitted for new front deck and stairs.
Good evening, Mr. Chairman and members of the board. My name is Amy Berkowitz. I'm at 87 Bayshore Drive, and my husband and myself are currently seeking to construct a new deck. And due to the current setbacks, if Mr. Harris could pull up the, you don't, oh, it's not working, okay. Can I, do you have the pictures of the, okay, you do.
They have
okay. So you can clearly see where, when you enter the deck from those 2 steps nearest the driveway, it starts at 7 feet. And as you walk across the deck, it narrows down to 4 feet. So we are just looking to square off the deck to make it an even 7 feet and add 2 additional steps to the front yard.
Questions? No questions? No? You're all fine with things? Okay. All right, is there anyone else speaking in favor? Is there anyone here opposed? All right, we know what we're doing. No further questions? All right, this hearing's closed.
Thank you.
We'll be right with you. We need a motion?
Make a motion to approve?
Second.
We have a motion to approve, and we have a second. Mr. Wolf?
I'm with the motion.
Ms. Hirsch?
With the motion.
Ms. Ferranti?
With the motion.
Mr. Montana?
With the motion.
I'm with the motion. It's approved.
Item number 8, 783 East Broadway, MBP 22/474/35, R5, Thomas Lynch Esquire for Julie Parizo, owner. Vary section 3.1.4.1, side yard setbacks to 3.1 feet each side, where 5 feet and 10 feet required. 4.1.4, side projections to 3.1 feet each side, where 4 feet and 8 feet permitted. Section 6.3.2, expansion of non-conforming structure, all to construct a new residence with deck.
Thank you, Mr. Chairman. And again, on this application, Thomas Lynch representing Julie Porzio, who is here with me tonight. Mr. Chairman, could I ask the board for a 5-minute recess? My client may want to discuss the matter with, there may be a neighbor here that she may want to discuss the matter with. Would that be acceptable?
Yeah, we can do that.
Right.
Okay, we're a 5-minute recess.
Thank you. I think we are prepared to go forward. Thank you for the, thank you for the indulgence.
Yeah, let me get us back on. Okay, so we're back. We're officially back. Okay. Go ahead, Mr. Lynch.
All right, so let me go back to the beginning. I'm here with Julie Porzio, seated in the front row with her husband, Joe. Julie and Joe are the owners of the property at 783 East Broadway. We've made applications for side yard setback variances under 3141. We've made a request for the projection with the eave and the deck in the rear under 414. And also, because the existing house is non-conforming, this is an expansion of a non-conforming structure. So, the clients bought the property back in 1999. They've had this as a seasonal home for the last 24 years. Joe and Julie reside in Waterbury, and now the intention is to make Milford their home. So they've employed Codis Bodie and Associates as well as Joe Rousseau to design the house that's being presented to you tonight. It is almost exactly the same house that this board approved similar variances for Ken and Carol Constant, the owners of the property next door at 791 East Broadway. So right from the outset, I want to just stress that, and I'm sure you've all driven down there, you've gone to the Greek spot, you've seen all the development on East Broadway. There's been many, many houses clients that I've handled applications for, and this is a minimum-sized house. So the existing house that was built back in 1915 is some 1,100 square feet. It's a 5-bedroom, non-conforming structure, and this is a very small lot. It's some 4,600 square feet in the R5 zone. But the existing house now has a 22-foot front yard setback. It has a 1.7-foot setback on either side of the house, on the east side of the house, and it's got a 5-foot setback on the other. So that the total of the two setbacks is roughly 7 feet. So the new house will have basically the same setbacks. It's going to be moving the house somewhat more into the center so that there's a 3-foot, 1-inch setback on either side. But the result is a 19-foot wide house. Again, this board has approved many, many 20-foot wide houses. This is a 19-foot wide house, and it's the same size as the Constance built on the adjoining property. So I want to state basically the hardship that exists here is the size of the lot. The clients have submitted plans. I wish we could put them on the screen, but you have the paper copies. Joe Rousseau has designed a house with 3 levels of living space. There's some approximately 1,200 square feet on each level, so the house will be roughly 3,600 square feet. It's going to have the garage, as we're well aware of most of the houses on East Broadway there, the lower level garage. There will be an elevator to service the house, so there's the 3 levels of living space. The typical open floor plan on the first level. The second level has 2 additional bedrooms, and then the master bedroom suite on the 3rd level. The building height is conforming with the zoning regulations. It's been determined through Joe Rousseau's elevations to be 34.6 feet in height. And that's it. I think, again, this is part of what's been going on down at East Broadway, the development of the properties. The gentleman who was here in the audience had a question as to how far out the house is going. He lives in the property to the 2 doors down from Julie's property. It's on the other side of the Constance house, and we've assured him through showing him the maps and the plans are on the website that the house will not exceed the length back of the Constance house at 781. I think I said 791 before. It's 781 East Broadway. So with that, I'm happy to answer any questions that you might have.
The new house next door, how close is that to the property line, do you know? And I don't believe we had a variance for that one.
I think we did. We went to the ZBA, and then we had to get a CAM.
The new one that's going up right next to it?
Yes, yeah.
I don't recall that one.
Yeah, we had variances and then we had to get CAM approval.
So do we know the distance between the houses right now? Because this, we're
I
looking
think
at...
on the Constance side to the Porzio side, that's the 5 feet. They got the variances again on each side. I think the 5-foot setback is on the side to this house.
Well, I'm just thinking, you know, because we're crowding the line over there, they're absolutely two brand-new houses. So it's like there's nothing else that's going to be put there for years. But anyway,
Well,
we might be looking at about 8 feet between the houses.
Yes, and the point that I wanted to make, Joe, is that the existing house has setbacks of 1.7 feet on either side. So this, on one side, it's got 5 feet on the other side. So the total, by moving the house to the center of the lot, it creates 3 and 3 rather than 1.7 and 5.
Any questions for Mr. Lynch? No? No questions. Anyone else speaking in favor? Anyone speaking in favor? I have to ask these questions.
Okay.
Is there anyone here opposed? Okay. No further questions from the board? The hearing's closed.
Okay, you closed the hearing. I was going to say,
Go ahead.
this will also go to the Planning and Zoning Board for CAM approval as well, so that it gets reviewed by that.
All right,
board.
so it still has to be reviewed. Okay,
Right.
thank you. Okay, this hearing's closed.
Mr. Chairman, I must recluse myself on this vote with my daughter living 4 homes away.
Okay, I really don't, I don't think that matters, does it, Mr. Harris? He's listened to the whole hearing, and he's saying his daughter lives four houses away. I don't think that's going to
He
matter.
said his daughter owns a house for it?
What's that?
I didn't hear what Mr. Montano
He said his daughter lives 4 houses away. He wants to know if he should recuse himself from the vote.
I
No,
don't
I
see,
don't-
see.
I don't think
Do
so,
you have
but
a
I'm
direct
asking.
financial interest in either in this?
She doesn't. No.
No, do you?
Do you have a financial interest in it? No. Okay. No problem. Okay. All right. We need a motion.
Motion to approve.
And seconded.
We have a motion to approve, and we have a second on the motion. Discussion? No discussion, I'll take a vote. Discussion, okay. All right, we have a motion to approve, and we have a second. Mr. Montana.
With the motion.
Ms. Ferranti.
With the motion.
Ms. Hirsch.
With the motion.
Mr. Wolf.
With the motion.
I'm with the motion, it's approved.
All right, thanks so much.
You're welcome. All right, let's see. You might have to help me here, Meg. New business? No, new business first, yes.
Nope.
No new business?
Welcome to Milford.
Any old business? Approval of last month's minutes. Did we look at last month's minutes? Everything okay? Say approve, say aye.
Aye.
Okay, all approve. Hearings for next month?
I've seen 2 applications so far.
2 applicants, I think we're going to have 1 appeal.
Okay.
Oh, except Francis, right?
Any further business? Motion to adjourn?
Second.
Okay, we have a motion to adjourn. This meeting is adjourned.